Good evening and welcome to our final episode of Season 2 of Know Your Rights. This is the show where you hear directly from lawyers who break down the law and explain the rights of citizens on common legal issues that confront Belizeans on a regular basis. Tonight, we will be discussing juvenile justice and adolescent rights. There is great concern when it comes to the growing numbers of youths involved in criminal activities. However, there are special measures in place for when they face the justice system. Joining us to give insight on this important topic is attorney Baja Shoman from the Legal Aid Center. Good evening and welcome, Baja.
Hi, good evening.
Well, thank you for joining us and bringing to us this topic at such a timely moment in the Belizean society, as well as I think 2 episodes away from when we actually discussed the CRC with another attorney, Ms. Diana Shaw. So it's an issue that sort of goes hand in hand. So can you start by explaining to us exactly what is juvenile justice?
All right. Juvenile justice is the criminal justice system for children.
Okay.
Now, we know from the onset children are very different from adults. So the way in which they process information, the way in which they react to certain circumstances in their life, and the way in which we have to treat them is very different. And so when they find themselves in conflict with the law and in the court system, there are certain measures that need to be taken to protect them.
Okay. So a juvenile is who exactly? Who is a juvenile?
All right. A juvenile is a child. And in law, we consider a child anyone under the age of 18.
18 years old or younger. And so in the justice system, you are from the Legal Aid Services. Tell us a little bit about your department and what you do.
Okay, the Legal Aid Center, formerly known as the Legal Advice and Services Center, is a department which is subsidized by the government. There are 4 qualified attorneys in the office which provide legal services to the members of the public who are unable to afford private attorneys.
Oh, okay. So do you always get to step in to juvenile cases, or is it only when you're requested?
It's upon request. This center is not fully free. Okay. It is subsidized. So there are fees, but we do take on matters when we are approached.
Okay. Let's get into some of the differences that exist when you're trying a juvenile case versus an adult case. First of all, do they use the same court system?
No. There is a specialized court that deals with children who come in conflict with the law. We know it as the family court.
Okay,
the family court does not only deal with child protection matters, it does not only deal with maintenance and custody. The family court also hears the criminal side of matters involving children. So in Belize City, we have a specialized court, and in Punta Gorda, we have a specialized court. Now, in the districts that don't have a specialized court, the district magistrates will hear those matters, and they're heard in camera. So there is still privacy for the child.
Okay. I think that's something very important you mentioned versus adult cases. Adult cases are usually open, but child cases are
they're closed. Yes. In an adult case, you can walk into court. Any person can walk into court as long as you're properly attired. You can sit down and hear the case. In child cases now, they're in camera, and that means they're closed doors and they're not to be reported on.
So can you walk us a little bit through the process of when dealing with juveniles going through each stage of the justice system?
All right. Generally, the first point of contact will be with the police. Yes. So if a child finds themselves in conflict with the law, they will either be detained or they turn themselves into the police at the station, no? Okay. But when they are detained by the police, the first thing that should be done is that a parent, guardian, or social worker should be called. Okay. That is one of the first fundamental things that should happen. Yeah. Following the parent or guardian being present, if there's an interview and it follows a process, the social worker would also be involved. When after it's followed that process, if the child is charged, then the child would be taken to the family court to be arraigned.
Okay.
Now, what is important is throughout the process of the child being in court, there is a community rehabilitation officer that is assigned to that child's case.
Okay.
If the child goes to court and the child is remanded because of the offense, the severity of the offense, the child is sent to either the youth hostel or the Wagner's facility. Those two organizations only host children. The child, if not on remand, is then given bail by the court, if it wasn't already granted by the police, no? And the child is put in care of a parent or guardian. That's important to note too, because even if the bail is obtained at the Supreme Court, generally one of the basic things that's necessary is for the child to be in place of a parent or guardian, and usually there's a curfew, so they need to be in by 6 p.m. and not able to come out until 6 a.m., something of that nature.
Okay. So I want to ask, why is this special treatment then? Is it the outlook of the courts that juveniles are less developed, they cannot be held fully responsible, unlike an adult who would necessarily commit the same crime or the same offense?
Well, yes. Children, developmentally, they haven't finished that process.
Okay.
And as you would recall with Miss Diana, when you were speaking of the CRC, there are protections that need to be in place to ensure that the vulnerable children are not taken advantage of. And so in allowing these protections in place, it allows for the child not to be taken advantage of and for them essentially to have what every other adult has, a fair trial and due process.
Okay, I remember Ms. Diana especially kept using a very important phrase, the best interest of the child. And I could tell that through the juvenile justice system, that is something they are seeking at that point. But it's interesting because you also have the other side where a lot of members of the public are saying that, well, you know what, that are kids, but that they do big people crime, they want to act like big people. Should we treat them like big people? What would be your response to that kind of criticism?
It is very touchy, but let me say this to you. At the end of the day, they are children, all right? Okay. And when you look at it, they are victims even though they're offenders. Okay, if we had preventative measures, if we had recreational activities, if we had different types of activities that would occupy their mind, if they weren't finding themselves in certain situations, we can't forget at the end of the day their developmental process and the fact that there are laws which protect them. So you can't just put them in a bucket and cover that bucket. They need to be protected as well.
You spoke a little bit of some of the outcomes if the juvenile is convicted. Is it that the court tries to ensure that the mechanisms they use for rehabilitation, if any, because you can correct me if you think they need more, for rehabilitation is really in the best interest of the child? It is not as harsh. It is to foster maybe the growth or to challenge this victimization that you've spoken about.
Well, remember, you said the term you heard thrown around is best interest of the child. Throughout the process that they're in the court system, the community rehabilitation officer works with that child. Okay. So that child is being guided for trial and for rehabilitation, and that community rehabilitation officer is also preparing reports to submit to the court on the progression of the child throughout the process that they've been working. Okay. So it's not like the court is just handing down a sentence willy-nilly. They are taking advice from the experts because each person has their own expertise. Yeah. And the court does take advice from the community rehabilitation officer.
We need to take a very short break, and then we will be right back to continue our discussion on juvenile justice and adolescent rights. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Baja Shoman, and we are discussing juvenile justice and adolescent rights. So, Baha, can you give us an understanding of what is a status offense under juvenile justice?
All right. A status offense is it is a non-criminal act.
Okay.
But it becomes criminal just because of the person's age.
Okay.
So, for example, for you and I to be drinking,
Yeah.
it's non-criminal,
Okay.
all right?
Okay.
But for a child to be drinking, it becomes a status offense. So it becomes an offense that the child is committing just by merely being under the age of 18.
Just being a child?
Yes.
Okay. So it's not a very serious offense?
No.
Okay. But would there be any situation where juvenile can be sent to jail for a status offense?
The status offenses are generally petty offenses.
Okay.
And again, best interest of the child, it is unlikely for a child to be sent to prison for a status offense.
Okay.
The court would seek other remedies when dealing with that type of offense.
Okay, but now what about other offenses, more serious ones? Are there any offenses where a child would have to then be transferred, that is so serious or severe that a child would have to be transferred to the criminal justice system?
Yes, there are two instances where children are transferred to the criminal justice system. In the instance where a child is alleged of committing a crime with an adult, in that case, the matter, unfortunately, it is heard in the magistrate's court. So the child is then tried with the adult, as opposed to the adult being tried with the child and taken over to family court. The matter is heard in the magistrate's court.
Okay.
Secondly, I know you would hear in the news the offense was indictable, so a plea wasn't taken. Those are more serious offenses. Those are the offenses that are heard in the Supreme Court.
Okay.
So after the matter has been arraigned through the family court, the PI would be held, and after that has been done, if it is found that there is a prima facie case for it to be sent up to the Supreme Court, it is then tried in the Supreme Court.
Okay, so that's very important because juveniles have to be cautious. I remember there was an incident where a person, he was a juvenile, but he was in association with adults, and a firearm was found in their vehicle. And so everybody was taken and tried in the magistrate court. And so from that perspective, he did not get the special look of being a juvenile. So it's very important for young people to be cautious of who they are around, especially if they're adults as well.
Definitely, but what I will say is that if the child is convicted of the crime they were alleged to have committed, the fact that they were a minor is taken into consideration by the court during the mitigation process. So it would be something that is used and presented to the court when the court is deciding on its sentence.
Okay. I remember there was an interview with the former Chief Justice, and I wrote down what he said. He says it's quite disturbing the number of juveniles who are being transferred to the criminal court, whether perpetrators and victims. Are there any special methodologies or special ways that they're handled currently under the Juvenile Justice Act that make some provisions for that when they are transferred into that system?
Okay. First, we don't have a Juvenile Justice Act.
Okay.
We have a Juvenile Offenders Act, which guides the court in handling matters where juveniles are involved. Currently, it is the family court that hears the matter. There is the option given to the offender at court if they would want the charge to be heard at the family court.
Okay.
I've been told from experience that generally, through their attorneys, when it's a serious offense, it is opted to go to the Supreme Court for whatever reason the attorney, having looked at the case, decides. But when you look at it, the family court is the first place where the matter is done. So the family court has prosecutors that prosecute the matter, and they are set up in a way that attorneys attend the family court as well. They represent children that are in conflict with the law there. And if the child is unrepresented, the CRO is there to guide the child through the trial process.
Okay.
And if necessary, the court can make orders requiring that a parent be present throughout the trial process.
Okay. It's a difficult situation taking a child through that process. What sort of challenges have you encountered in the current justice system?
Well, there are many challenges. When you look at the fact that we're never going to have enough community rehabilitation officers. It's always going to be strapped for resources. One of the major challenges I do see is the lack of legal representation. If we're saying that children are vulnerable and we need to ensure that we protect their rights, one of the ways in which we can do that is through legal representation.
Okay, okay. Do areas that you would say lacking in infrastructure of the society also play a role? And I ask this because I remember when Ms. Shaw was here, she was speaking to me behind the scenes, and she was basically saying you don't realize how our lacking resources play a big role in that, apart from human resources, but testing and laboratories for evidence for cases. For instance, when it comes to sexual abuse, the limit they put on the evidence being valid by our courts because of our laboratory resource here is only a year. And you think about a year, within a year you have to go and report your case. That's a very short time, but it's kind of strapped by the resources we have here as well.
Definitely, lack of infrastructure and the lack of resources affects the matter, because what you have to look at is in the media we will hear X, Y, and Z, and in social media we will hear A, B, and C, but when you look at what is heard in court and what is accepted as evidence, it is very different. And that is where there's a bit of a misconception, because you may be told the child was sexually exploited, but if there is no scientific evidence of that, what is the court to consider? So that is what they have to, that is what great consideration needs to be given to, because what the court can accept as evidence is what would be taken under consideration when determining the trial.
Okay. So we just need to take one more short break, and this will be our final break, and we will be back to continue our discussion on juvenile justice and adolescent rights. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Baja Shoman, and we are discussing juvenile justice and adolescent rights. So, Baja, we don't want to only give the impression that the law steps in when juveniles have done something wrong. We want them to know that the law steps in also when they are being wronged. And one of the areas of prominence right now, unfortunately, in our media is that there are a lot of sexual offenses against young people. What protections do young persons in Belize have when it comes to sexual exploitation?
Okay, there are several ways in which a child is protected. The Criminal Code Act and the Commercial Sexual Exploitation of Children Act deals with offenses and creates offenses for certain actions which are done against children, and it is done to protect them and so as to not have them being exploited by adults. One of the things that we look at when you look at the criminal code, a fundamental protection in there is the age of consent.
Yes.
A child cannot legally consent unless they're 18 years old. What does that say? All right. If I am 13, even if I am telling you yes, legally I cannot do that, so there is no consent. All right? Children have a right to a childhood, and so the law is protecting that. A person cannot agree to have sex, and legally you will not be deemed to have had that permission from them unless that person is 16.
Okay. Okay, I know that's a very interesting one, and the media especially comes on a lot of scrutiny. I see on Facebook when they write such and such adult man has sex with 12-year-old or has sex with 13-year-old, and a lot of people write, that's not sex, that's rape. That's just that, when, you know, she's not a consenting adult.
Well, because of the nature of that offense, rape involves force, rape involves duress, and it is not that type of offense. So previously it was known as carnal knowledge.
Yes.
And now the law has evolved and it's now unlawful sexual intercourse. And the law definitely protects both boys and girls when it comes to those types of offense. Previously, you would see in the legislation a lot of her and him. Now, a lot of the legislation has been changed to person. What that means, it's no longer gender-based. It is encompassing both sexes, and it has protection for both sexes.
I know a lot of the studies will outline that there is a very strong connection, and you mentioned it in the beginning, that there's a strong connection between child victims and child offenders. If you are a victim of a certain heinous act when you're a child, it is a possibility that that could spiral you into being a child offender. So what do you think are a couple areas of priorities we need to look at, or areas that we can push for more prevention before the child is harmed or before the child spirals into being an offender?
One of the things that we need to look at is awareness.
Okay.
We need to make people aware of their rights. We need to make people aware of the mechanisms that are in place to protect their rights. We need to have extracurricular activities for children so as to not have them stray. We need to ensure that with the protection of their rights and the legislation that is there, that is being enforced. Because if we have legislation but there is no enforcement of that legislation, then what are we left with? So one of the things that we need to look at is we need to have school systems bringing awareness of what their rights are. We need to have more social workers. We need to have more infrastructure that can help us or assist us in dealing with these matters if the child has been in unfortunate circumstances of having been exploited. So there are a lot of things that we need to work out, but I think the primary thing that we need to do is awareness and having people understand their responsibility as well. Because if you know a child is being exploited, you have a responsibility to report that. I have a responsibility to report that. So if we use awareness and responsibility and beef those two up, I think we would be able to better protect the children.
Yeah. Thank you. And well, unfortunately, we have come to the end of our last show for season 2 of Know Your Rights. Thank you, Baja, for joining us and providing important information on tonight's topic. Tonight's episode repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for your viewing on Facebook and YouTube. We thank you for tuning in tonight and all season long. We will take a break and then return with a fresh approach and new topics in season 3. Good night and see you next season.